Hello and welcome to the Way to the Law podcast. I'm Helen Waite and I'm once again joined by my colleague Sarah Keily. We are talking today about alternatives to going to court. The court system at the moment in this country is struggling. There are too many cases, not enough court hearings and not enough judges. So we are finding that there are more and more delays. And sometimes, which can be very distressing for clients that have been waiting months for a hearing, you can be a day or two before the hearing and the court will just pull the hearing because they haven't got a judge, which adds to an already distressing situation, just makes it harder and more expensive. So we are trying as much as possible to look at alternatives to going to court as a department. And we are all, in our department, all the fee earners, all the solicitors are members of Resolution who sign up to a code of conduct to try and resolve matters amicably and where possible by not going to court. And as a department, we have got we've got mediators, we've got collaborative lawyers, we've also got a couple of people who practice the one couple, one lawyer, and we are also pretty experienced at private FDRs and sending people to arbitration. So Sarah, do you want to talk about mediation, being a mediator?
Yes, I am one of the mediators in the team. So mediation is a voluntary process, an alternative to court, and it's a really positive forum for separating couples, parents to talk about their issues, whether that's arrangements for their children or sorting out their divorce proceedings and the financial issues associated with that in a more relaxed and non-confrontational environment. And the mediator is there as an independent, impartial person who guides their discussions and keeps them on track, but largely allows the couple a space to have their discussions and to be heard. The mediator doesn't make the decisions for the couple. The mediator doesn't give specific advice. The mediator can give legal information and can talk through legal principles and the approach that the court might take to certain issues. But the process is really led by the couple, and as well as being generally a cheaper option for couples seeking to resolve issues, because they're paying the mediator, but they're paying one mediator rather than both paying their own lawyers. It can also be a more rewarding process because the couple themselves have reached their set of proposals themselves with the help of the mediator, but really they've been the ones that are driving the discussions and making the important decisions, rather than feeling that that's been taken out of their hands by their solicitors or even by the court. So,
and do you think part of the mediation process is that the two of them have to communicate?
Yes, and obviously there are cases where the cases that aren't suitable for mediation, where communication can't happen for a number of reasons. So, for example, if there's been domestic abuse, mediation isn't going to be necessarily appropriate. But it cuts through a lot of the sort of noise that you might have in cases that are being dealt with through solicitors or through court proceedings. For example, in a financial case dealing with the financial disclosure, the couple will come to the mediation session themselves with their financial documentation, and if a query is raised, the other person is there on the other side of the table to explain what that entry is on the bank statement, rather than it going from the client to their solicitor to the other side solicitor back to them. And it really can be a much more efficient and productive process in the right case.
And I think it's less likely that there will be unanswered questions or that elephant in the room, because they're addressing each other. And as you say, any queries that come up, they can ask them directly. They can look into the whites of their eyes, as it were. But I think there's something different about asking a question to somebody directly and getting an answer, rather than it going through a letter and then getting another letter in response.
Absolutely, yeah. And it hopefully breaks down those barriers of receiving a letter from your other half solicitor is always going to have that sort of slightly unpleasant
Yeah.
feel to it. Whereas being able to have those discussions with a mediator there, face to face or on screen if you're doing it remotely, it really does flow better, and hopefully it builds that there has to be an element of trust,
Yeah.
and it builds on that to the point where once a set of proposals is arrived at, the couple do feel that they feel some sort of ownership and they feel proud of themselves for getting to that point, because it's not an easy task always to get there.
And if they reach, so if they're mediating in respect to financial matters and they reach an agreement, what happens with that agreement that they reach in mediation?
So ordinarily, the proposals that they arrive at the end of the mediation process will be drafted into what's called a memorandum of understanding by the mediator, which is a privileged document, so it's still private between the couple, setting out where they've got to in terms of their final set of proposals, and they can then share that document with their respective solicitors and have it put into a legally binding order.
And what about if they reach an agreement about the children?
If they're mediating about the children and they come to a set of proposals about children, then the mediator can draft that into a parenting plan. Now, that isn't the same as having a court order, but often once a couple have gone through
the time and effort
of a mediation process and come out with quite specific proposals about the arrangements for their children, which could cover a range of issues, not just what days the child's going to live with which parent, but also schooling, holidays, the approach to mobile phones, things like that. If that's drafted into a parenting plan by the mediator, which the couple both sign up to, often you don't need it to be put into an order. If later on things break down or circumstances change, then obviously they've always got the option to go to court.
But I suppose if things in the future break down, they've got the option as well to go back to mediation,
of course,
and to try and resolve it in the same way.
And people
that they do.
They often do. Will go back to mediation, particularly if it's been successful the first time around. If things change in the future,
can children come along to the mediation?
So children don't come along with the parents, but if you are a specially trained child inclusive mediator, and we have a child inclusive mediator in the team, they can meet with the child on their own, and it's part of the mediation process. So it wouldn't just be that the child would come along. The mediator has to be mediating already with the parents. Both of the parents have to agree that the child can be seen by the mediator. The mediator will then have a session with the child. That session is confidential between the mediator and the child, and the mediator will only report back to the parents what the child is comfortable being reported back.
Okay.
But that can be really, really useful when there's often
a sticking point.
Often children will say what
one
their
thing
parent,
to one
one
parent.
thing to, and the same thing to what the other parent also wants to hear. And that can be difficult for parents who are trying to resolve a conflict if they both feel that they're listening to the child. So having the child spoken to by a child inclusive mediator can be helpful.
And another option that we mentioned at the beginning is the collaborative process, which is along similar lines to mediation, in the sense that everything is done, or most things are done face to face. There's no letters going backwards and forwards. There are emails, but an email that is sent will be sent to all of the parties. So it's not like a solicitor's letter. It's very inclusive. But to be able to enter into the collaborative process, both parties need to obviously sign up to it, but also need to instruct a lawyer that's collaboratively trained. And the big difference is that those lawyers will be working together rather than against each other to try and help the parties to come to an agreement. So there's a shared focus in the four parties.
And a shared commitment at the outset not to
go to court. Yeah. So that's the other thing that sets it aside, is that they will sign up to something called a participation agreement, which effectively means that they will not go to court. So if the collaborative process breaks down, they have to walk away from it and instruct different lawyers.
Which incentivises people not to.
I think it absolutely does. And I think, again, I always explain to clients that if you're going into the collaborative process, you have to understand that you're going to have to do a lot of the work, because the purpose of the lawyers is not to speak for you or to interject. It's to help, but it will still be in the same way that mediation is. It will still be the two parties talking to each other directly. And that can be it's really hard work, because obviously they've got the emotional element to it. And so it's very clear that everybody understands from the outset that it is going to be hard and that there is going to be a lot of direct communication between the two parties. But again, because of that hard work, it means it's less likely to break down because so much effort has gone into it. And I think it's just a different way of working. But the other benefit to the collaborative process is that any agreement reached, say, in relation to the finances, can be drawn up as a consent order. Sitting around the table, so we can go through, in the same way you can at mediation, we can go through the Form Es. If there are any queries, they can be asked about. We can work out what further documents are needed. It's all done by agreement. And then if we're able to draft a consent order, we can do it sit around the table. And then when we've got the final version, we can come back and say, right, is everybody happy with this?
I always think it's the only element that is a bit like when you see on American TV shows.
There is an American element to it, with the anchor statement.
The lawyer and the client all sitting around the table together.
Yeah. But that's the other thing that is very American, is at the outset we will ask the clients to set out, we call it an anchor statement, set out in writing why they want to do, what they're trying to achieve, and doing it collaboratively.
To keep them focused
So if things are getting, a bit heated or emotive, we go back to remember why you're trying to do this. And I think as well, as part of the collaborative process, we can bring in other professionals who are collaboratively trained. So we can bring in, if we want a barrister's opinion, we can bring in a barrister, we can bring in financial therapists, financial advisors, pension experts.
Yeah.
But the difference is it's done sitting together.
It's more transparency.
And I think at the end of it, everybody feels a bit like they should give themselves a pat on the back.
Yeah. I do think there's a lot to be said for having that face-to-face transparency. It removes the doubts that in sort of the traditional sense of the word, when we're speaking to our clients and it's a case of us then sending a letter in the traditional way, you don't know what the other person is thinking.
I mean, it's the same in any area of life, isn't it? If you speak to somebody directly, openly, it's you tend to clear things up, things move forward a lot quicker than if you talk to somebody else who then talks to somebody else who then talks to them.
And there's not that second guessing of, well, why do you think they've said that? And should I be, am I going to be weakening my position if I say something different? I just think it's got to be better and more efficient, as well as
the other
money in the long run.
To the collaborative process, which is similar, I suppose, to mediation, is that the parties can decide on the time frame. So they can decide, subject to everyone's availability, how quickly the next meeting is, and how quickly they can potentially resolve it.
Yeah, and also things like valuation evidence, whereas in the court process you might have to get certain things for the purposes of the court. In mediation and collaborative law, if a couple is happy to say, we'll use this value for this and that value for that, and we'll move forward. It's more flexible, I think, and bespoke.
Yeah, and I prefer, I must say, that when we've completed a case collaboratively, I get more of a sense of satisfaction and achievement than a big battle through the courts that nobody really wants. And as a firm, we also, not all firms do this, but we also have the one couple, one lawyer, which means that in certain circumstances, we've got family lawyers who will act for both parties.
Yeah, I mean, it has to be in the right case. But I always think of it as kind of mediation plus, in that it's a very similar setup to mediation, in that you've got one professional in the room who is helping you to have your discussions. But in the one couple, one lawyer process, you can take your role slightly further and
draft the documents.
You can offer advice, and you can draft the documents for them. So I think in the right case, that's a brilliant option, because you do have lots of couples who just, that they know what they want to agree, and they don't actually need as much help getting to the end set of proposals, but they need help getting it implemented. And
I think they need to understand, they need to be able to make an informed decision about what they've agreed.
Or they might need help instructing a pensions expert or a company valuation or something like that before they can finally reach their agreement. But I think that's been a really positive step forward in the last few years.
And something else that we're doing more and more regularly now is private FDRs. So an FDR, just to explain, is a financial dispute resolution hearing where the judge would give, as part of the court process, in a financial case, all of the financial disclosure would be before the court. Both parties would have made offers, and at that hearing, a judge will say, well, this is what I think would happen if I was deciding at a final hearing, at the end of this matter, this is what I think would happen. And then that will hopefully, generally, guide the parties to negotiate and come to an agreement. The problem is that it is now taking between 6 to 9 months to get to, if you're lucky.
I was going to say, that's probably optimistic.
Yeah, to get to an FDR through the court process, and it's not unusual for them to be moved or, things to change. So what we as a profession have developed is private FDRs.
Yeah, and I think, my one bugbear about it in explaining it to clients is that we call it a private FDR, and most clients haven't got a clue what an FDR is, quite understandably. So I wouldn't be surprised if in the next few years it starts to get a more user-friendly, name. But they are really, really common now and really effective in that we deal with the financial disclosure, we get the case ready in the same way that we would if we were in contested court proceedings. And sometimes we are in contested court proceedings, but we branch off down to the private route for a number of reasons, as you say, so that you can actually know that if you pick a date, that's the date that is set in stone and it's only going to be moved if it's by agreement. You have a judge who knows what they're talking about. They are actually a family law expert. You are in very nice barristers' chambers, getting sandwiches
with
and
a nice coffee,
endless supply of tea and coffee, rather than in a grotty county court building.
But also,
and it's the time frame. You can say, right, we're going to get this done, and we're going to have our private FDR in 2 or 3 months' time, and everybody works to that date, and the date arrives, and you have your hearing. So,
and I think again, it comes down to that investment, because the parties have to pay for the judge. It's an additional commitment, isn't it? It shows that you've got an intention to try and resolve it. And I think the other thing is with the court-ordered FDRs that you will generally have 4 ordered at the same time on the same day.
That's a good
Whereas
point.
with a private FDR, you've got the judge's attention all day. And they have got time to read the papers.
And they are effective. And the court FDRs as well. And I know clients have said to me, but it's still voluntary. And what if after the judge gives their indication, we don't come to an agreement? But in my experience, I would say 9 times out of 10, an agreement is reached at the FDR or very, very soon after. It's very rare that you would go to a private FDR and then still be left significantly far apart in your positions. But in that situation, what I would advise a client then is to follow it up with or to plan alongside it arbitration, because obviously arbitration, as well as still being a form of alternative dispute resolution in that it's outside of the court process and it's voluntary, the big difference is that it is legally binding. So I always describe arbitration to clients as just a private final hearing. It's the same as going to court, but again, it's you pick your judge, you pick your date, you're in much nicer surroundings. But the decision that is made at an arbitration is legally binding, which is different to a private FDR. But if you plan them alongside each other, you're effectively mirroring the process that you would undertake through the court, but you're doing it all on a private basis. And that gives you the safety net that if your private FDR isn't successful, you've got an arbitration date maybe 2 or 3 months down the line. If your private FDR is successful, you cancel that. And
I think it focuses
done.
Everybody's minds as well to know that if you don't settle it, there's another date coming, and everybody's also aware there's more cost. And I think that timetable, again, even if it's a subconscious thing, it makes
keeps people on track.
Yeah,
I think so.
So there are lots of different options.
I just think if you look back 15, 20 years ago, yes, mediation has always been there and has always been a really useful tool for family lawyers, but there wasn't the same level of options available to couples as there is now, and that has grown from the fact that the court process is so under-resourced. But actually, obviously it's a negative that the court process is so under-resourced, but as a profession, I think we've really answered the call for that and plugged the gaps, and continue to do that with things like One Couple, One Lawyer.
I think it's ever changing, isn't it? I'm sure in the next 15 years there'll be other options, just trying to find the best way to resolve things.
And I think it speaks to the nature of family lawyers as a profession, that we are out to try and do the best for our clients and their families, and it isn't a case of us just saying, oh, sorry, you've got to wait 2 years for a hearing. People are constantly trying to think of different ways
I think as a team as well, I would say that in our team we are all going to court is an absolute last resort, and if we can then move it away from the court to an alternative means of resolving it, we know that that is going to be the best thing for our clients.
I agree.
So I hope that's been useful, and thank you for your time, and we'll see you next time.